Let's talk about what you need to check before signing an employment contract. A job offer is usually followed by an employment contract. You need to study both in detail before you sign. You need to check that the document reflects what's been agreed. To do that, you need to build a checklist. You have to make sure that all the required information is there. You can use your checklist, and some of the pages of this video may be of help. If you don't like something, negotiate. You need to learn how to negotiate. You also need to know how to sign. Please see our lesson on signing docs. So why should you be careful before signing an employment contract? It's because you need to understand your obligations, you need to protect your rights, avoid surprises, ensure that your compensation and benefits are fair. You need to clarify expectations and responsibilities and minimize legal and financial risks in the future. You need to anticipate potential problems. Remember, until you sign, you can negotiate. With a salary, you've got to make sure that it's reasonable and in line with industry standards. This can only happen if you research the role, check recruitment websites, and if possible, speak to some recruitment specialists and other people doing similar jobs. You must arrive at the interview prepared. Some employers tell you what they're offering, and some ask you what you want. You need to have an idea of the right salary before you enter the interview room. You need to have the answers ready. If the offer is too low, but close to your expectations, say to the interviewer that you find it a little low, but you'd like to understand all the other benefits before making a decision. If the offers increase quickly, it could mean that the employer does not believe that the benefits offered will change your mind. Now we come to the bonus clause. A bonus clause sets out the terms under which an employee may receive additional compensation beyond the salary. Bonuses can serve as incentives, rewards for performance, or retention tools. However, just because there's a bonus clause, it doesn't mean that you're guaranteed a bonus. Typically, there are 4 types of bonus. There's guaranteed bonus, which is defined in advance in the employment contract usually. It could be a sign-in bonus or tied to achieving certain goals. There's discretionary bonus, which is totally at the choice of the employer, even if you perform well. Performance bonus is the third type. It's often based on revenue targets, client retention, product delivery, or other financial targets or sales targets. There's commission bonus also. That's common in sales roles and usually a percentage of sales. So how does one check the bonus clause? Is the bonus payable in cash, shares, or a mix of the two? Is it guaranteed? Check the amount, timing, and conditions. If it's discretionary, look out for words like may, at its discretion, or subject to management approval. These may suggest that the company can choose to pay you a bonus or not. Is the bonus pro rata the portion of the year you've been working or not? Do you need to be actively employed on bonus payment date? If it's performance-based, when and how is your performance evaluated? Are there any clawback clauses that can require you to pay back the bonus even if you receive it and then leave soon after receiving it? Would you lose the bonus if you resign or are dismissed? What if you've earned the bonus but leave before it's paid? If you're dismissed, are you still entitled to pro rata bonus? Can the conditions for the bonus be changed by the employer retroactively? If you want to make a change to the contract, you may be told that it's standard contract and cannot be changed. In such cases, if something is important for you, ask for a side letter to confirm what you need. Even something as simple as the start date for your employment can get tricky. You have to check if it's the date you've agreed, and check that it's not incorrectly set to be at a weekend or on a public holiday. It does happen. A new contract with a subsidiary or branch cannot have a totally new start date. This we discuss in the section below. And this is called continued employment. Many people transfer to another unit of the company after a few years and get a new contract of employment. If the new contract does not state that it's part of your continued employment with the company and does not restate your original start date, all your employment, pension and severance benefits based on years of service could get reset to zero. Many people have lost out on benefits because of this, so please watch out. Remote working and working from home are big deals these days. So you need to check if you're entitled to them and if the employer can remove that entitlement, and if so, how? Would it compensate you if it did? Is there a company policy on it? Can you get a copy? Please be careful. The employer may interpret you asking for the policy quite negatively, so please step carefully. Probation period is another thing to check. What is the probation period? What are the performance expectations to get the full-time job? Note that across the world, unpaid probation periods are usually illegal. Only a few hours of activity can be offered unpaid. If you'll start the probation period at a lower salary, will it go up at the end of the period? Does the contract say so and state the subsequent salary? If not, why not? If you've offered to start on a low salary, will you have the right to renegotiate your salary at the end of the probation period? Probation periods can be 1 to 3 months, and in some countries, it can go up to 6 months. Longer periods tend to be illegal in most countries. A probation period means that the employer will not commit to you until they've seen your work. If they will also pay you less during the probation period, that's 2 cards in their favor. So you can consider negotiating if you choose to. Your place of work can change. Check your employment contract to see if the employer can change your place of work. What happens if you do not agree? Imagine getting a job at a place near your home so that you can spend more time with your family and friends, and a while later being asked by the company to transfer to an office on the other side of town or even in another city. If the employer has this right without any limitation or test of reasonableness, they can also use it to lay you off cheaply. It could simply offer to relocate you to another city, and if you do not agree, you get terminated with little or no notice and without any severance costs. If you've agreed to the clause, reason for dismissal could in such a case be simply a breach of contract. If you're happy to take the relocation risk, check if your relocation costs would be paid. Relocation assistance. Does the employer provide assistance if you initially need to relocate to take the job? This could involve moving costs, temporary accommodation, and help with finding a house. If so, are there any conditions tied to relocation assistance, like having to stay for a minimum of period or repaying the costs if you resign within a certain period of time? It is reasonable for an employer to try to cover its risks, so please tread gently. It gets quite complicated if relocation costs would only be compensated after the end of the probation period. This may force you to not relocate your family until the end of the probation period. If that happens, would the employer compensate you for relocation costs if you bring your family over after the probation period's ended? Watch out for this, read the fine print, and negotiate it at the start. This should not be difficult. If you relocated after a while in the company, say after a couple of years, and you accept, would your relocation costs still be reimbursed? Benefits. What are the benefits that the employer offers you? These could include holiday, health, dental or vision insurance, medical checkups, pension fund, company car, etc. If you can, estimate the monthly or annual value of some of these benefits to see what they're worth. This is a good way of comparing different job offers like for like. Work expenses. Does the employer reimburse work-related costs like inviting clients to lunch, traveling to meetings, daily commuting to work, or offer you lunch subsidies in some form or other? Annual leave. How many days annual leave will you get? Can you roll unused leave from one year to the next, or you have to take it or lose it? Are there any block leave requirements? Block leaves are common in the financial industry to ensure that internal data and trading systems cannot be regularly manipulated by somebody, and they're often 2 weeks long. So the company disconnects you from the company's systems and computers for 2 weeks to make sure nothing blows up. What is the policy on medical leave? After how many days of sick leave do you need to provide a doctor's certificate? Does the company offer maternity and paternity leave? Performance review. Are there annual or semi-annual performance reviews to assess your work and discuss possible promotions or salary increases? Who conducts these reviews? Only your managers or also your peers? The performance review by peers is usually referred to as a 360 degrees review. If your company doesn't encourage you to get that, it means that they're trying to control your performance reviews and be able to change it as they wish. That's sometimes not a good sign. Some employers offer health insurance and some offer to pay part of your own private health insurance. If offered, check what it includes. Check if it's just medical or it includes dental and vision. Does it include annual checkups, doctor's visits, medication, hospitalization, for example? Do the benefits cover just you or your family too? Are dental care and vision care also offered? If dental care is offered for the family, would it cover orthodontic, which is corrective braces for children? That can be a large cost item, and if a company offers that, that's a great sign. Do you have to pay part of the cost of these insurances, or are they all paid by the employer? Disability benefit. Does the employer provide short-term or long-term disability benefits in case you cannot work for some reason? Confirm if the benefits automatically offered or you have to opt in and choose to receive it. Death benefit. These are benefits offered to the spouse in the event of the death of an employee. Some companies offer these based on the length of service. Some companies may only offer a contribution towards your life insurance. Confirm if the benefits are automatic or you need to opt in. Retirement age. What's the employer's policy on retirement age? Is there a mandatory retirement age, or is retirement based on mutual agreement after reaching a certain age? Most companies have an age above which the employees can voluntarily apply for retirement or be asked by the employer to retire. In most countries, Social Security contributions for older employees get quite expensive. This motivates some employers to dismiss or retire employees soon to save costs. It is not recommendable, but unfortunately, it happens quite commonly. Pension plan. Most employers are required by law to provide a pension plan for their employees that earn above a very low level of salary. Often, the employee has to pay a part as a deduction from salary, and there's another part that's paid by the company. Many companies offer to pay more than the employee's share. Assets in the pension fund would often be invested by the administrator of the pension fund, although some pension funds allow the employee to make periodic investment choices. At retirement, the employee can sometimes withdraw all the assets in the pension fund in one lump sum or receive it as an annuity, which is by installments, over a period of years until death. It's very important to know how this would work with your employer's pension fund. If you've been working for a company for many years, you need to carefully plan your retirement. Disciplinary process. Nobody starts a new job wondering what would happen if the employer is not happy with his or her performance. It just does not sound right. However, it's important to know how performance issues would be addressed. Are there regular feedbacks, warnings, performance improvement plans? What would be your rights if you were to be terminated for poor performance? Would you be entitled to the notice period? Would you maintain any bonus entitlement? If you ask these questions at the point of accepting an offer of employment, you could give the wrong impression. If you cannot find the answers, try to ask for a copy of the company policies on employment, or ask someone who works or has worked for the same employer. Please be careful not to give the wrong impression. Notice period. What's the regular notice period if you wish to resign or the company decides to terminate you? During the probation period, there may be a short notice period of 1 week or even 1 day, depending on where you live. Resignation. If you resign, you would normally need to give notice in line with the notice period requirements. Is it the company practice to keep you working until the last day, or do they expect you to leave the company immediately and stay out during the notice period? These are usually decided on a case-by-case basis. Dismissal. What are typical grounds for dismissal, i.e., what are the reasons for which the company can terminate your employment? If you're dismissed or terminated, would you still be entitled to the notice period? Again, it's not easy to ask about this at the start, unless you ask to see the company policies and read them. If they do not have a standard book of policies, that's not a good sign. Governing law. A typical clause on governing law is shown here. Any disputes arising under this contract shall be subject to the laws of the country where you're in, without regard to conflict of law principles, and be subject to the jurisdiction of the courts of the city that you're in. It's always better to have this clearly stated in any contract. In theory, a legal dispute can be started anywhere in the world, and you would need to hire a local lawyer to defend yourself there. If the dispute is started in an unreasonable location, the court may decline the case and say, "This is not my business, so please take it somewhere closer to where you live." This clause is normally acceptable if it uses the local laws and courts. This should prevent referral to other courts. It's best to always check with the lawyer if you're not sure. However, if the jurisdiction and courts are not near the city where you will be working, or are in another country, which can sometimes happen if you're working for a multinational company, it's worth clarifying why and trying to change it to something more reasonable. Intellectual property, or IP as it's often referred to, includes inventions, designs, discoveries, developments, trade secrets, computer programs, etc. that are conceived, created, or developed by an employee alone or with others, and that A, relate to the business of the employer, and B, result from any work performed by the employee, and C, are developed using the employer's equipment, supplies, facilities, or trade secrets. These are considered to be the property of the employer. The employee is usually expected to assign all his or her rights to such IP to the employer. If you're likely to be engaged in work that creates IP, you need to list any IP you already have from previous projects in an attachment to the employment contract in advance. Check what would happen to the IP you've developed outside work and in your own time whilst you're working for a company. Check what obligations you may have after leaving the company. Sometimes you may be required to help with registering certain IP without compensation. Please check. If in any doubt, ask for clarification and negotiate the clause until you're happy with it. Many people do. Many companies actually expect you to negotiate these clauses and would be surprised if you did not. Now we come to the non-compete agreement. In most popular sectors of the economy, there are clauses in employment contracts that prevent employees from doing the same job at some or any competitor after they leave for a period of several months or longer. These clauses can effectively prevent you from following your profession and making a living in another company doing exactly the same job. Their intended effect is to protect your employer against competitors. However, some non-compete clauses can be really excessive. If someone's working in a supermarket, the idea that he or she should not work for another supermarket for 6 months or a year after leaving sounds crazy and unreasonable. However, it may be reasonable to expect that if someone who's a designer of specific equipment at a cutting-edge manufacturing company wants to move to the competitor, he or she could significantly affect the competitive positioning of his or her previous employer. In such a case, a 6 months or a 1-year non-compete clause may be justified, provided that he or she has earned enough money to survive for a year, or if the new employer will offer a sign-in bonus or other compensation. Every year, there are thousands of such clauses that get challenged in courts. The logic used by courts is always centered on reasonability. Check the non-compete clause in your contract and see if it seems reasonable to you. Severability Clause. An example of a severability clause that a lot of people find confusing is shown below. It reads, if any provision of this agreement is held to be illegal, invalid, or unenforceable by a competent court, the remaining provisions shall remain in full force and effect. The parties agree to replace any such invalid or unenforceable provision with a valid and enforceable one that most closely reflects the original intent of the parties. It basically means that if the company has put something in the contract that they don't believe will be acceptable to a court of law, that they can remove that clause and say everything else is still valid. It's very common to find this clause in employment contracts, as employers also realize that some of the provisions could be too broad, unenforceable, or simply unreasonable and could not be justified. So they risk that if there's a dispute and it goes to court, that the clause and the whole contract could be nullified by a court. To avoid the whole contract becoming null and void, which means legally invalid, by a court, they include this clause so that the remaining clauses do not drop away if an employee sues them. It is unusual for this clause to be negotiated and is regularly found in most employment contracts. Just before signing an employment contract, many people feel just like this tree, standing all alone in the middle of a large field. Never sign an employment contract until you fully understand it and are happy with it. Research, ask questions, and think.